Members, we have a quorum. We've reached the appointed hour. The meeting is now called to order. Let us deal with the questions raised by members on the 27th of May. The administration has given a written reply. So over to you, Mr. Liu. Now, please take us through your reply. Now, before the meeting, we have issued 2 documents for members. One is to respond to questions raised by members on the 27th of May. And there were 2 questions. The paper deals with 2 issues. First, 14A, concerning the definition of debt instrument, which is about an anomaly, and the other is under the SDO, how a stamp can be made subsequently, and how to deal with the procedures. First, concerning Section 14A of the IRO, 14A4, which is about the definition of debt instruments. Now, under the existing 14A of the IRO, it is provided that a debt instrument, a tax concession at 50% of the prevailing profits tax for interest, income, and trade profits deriving from any qualifying debt instrument. The current definition of debt instrument includes one of the following criteria, and that is, it is issued on or after the 14th of November 2003. But going back to history, the IRO 14A was implemented in 1996, and when the provision was enacted, the definition of debt instrument at that time was that issued was as read as is issued on or after the commencement of this section. To facilitate users of the law in the IR Amendment Ordinance 2011, we want to replace the phrase "the commencement of this section" with a clear calendar date. Unfortunately, the date 14th November 2003 was instead adopted for that definition in the amendment exercise in 2011. By anomaly, the administration proposes rectifying this anomaly via Clause 6 of the bill by repealing the date 14 November 2003 appearing in paragraph G of the definition and substituting 24 May 1996. So all the debt instruments issued after 24th of May 1996 would be covered and receive the concession. And we have consulted the IRD. Now, since the amendment of the law, the IRD is not aware of any case in which a claim for the relevant concession was denied solely because of the anomaly. Since the commencement date of the Inland Revenue Amendment Ordinance 2011. Having regard to the discussion at the last meeting of Bills Committee, the administration intends to propose a committee stage amendment to Clause 6 of the bill to state clearly that a qualifying debt instrument issued on or after 24th May 1996 but before 14th November 2003 may be treated as a debt instrument within the meaning of Section 14A of the IRO to the extent that it would have been if paragraph G of the relevant definition as amended and always been in force, and any previous assessment made on the above basis is declared to be valid to the extent that it would have been if paragraph G of the relevant definition as amended had always been in force. So it is applicable to previous assessments or assessments so that the debt instrument will be regarded as having the qualification to receive concession. As for the amendment, this is in Annex B of the paper, and we have another paper on CSAs, and it has also been incorporated in that paper. I'd like to thank the legal advisor for giving us some advice beforehand, and we have incorporated the advice. If members don't have any questions, then we'll move on to the second question. At the last meeting, a member raised the question in relation to the operation of stamping arrangements in case of an instrument which is not duly stamped. In studying the Blue Bill, we propose that sections 47F and 47G, which are intended to provide for the stamp duty relief for relevant specified transactions under a qualifying investment arrangement in a specified alternative bond scheme. The proposed section of 47I provides that an instrument in that relation to such transactions is not duly stamped unless it is stamped with the stamp duty with which it would be chargeable. But for section 47F and 47G, or it has, in accordance with section 13, be stamped with a particular stamp, or by way of a stamp certificate denoting either of it is not chargeable with any stamp duty, or that it is stamped. Now, if, say, one side has not asked for exemption, or that an instrument is not duly stamped, we said that the parties concerned can apply to the collector of stamp revenue for adjudication of the relevant stamp duty implications under Section 13. If there is overpaying of stamp duty, then the collector has power under Section 49 to cancel a stamp inadvertently used or stamp certificate inadvertently issued, and to effect a refund of the excess stamp by stamp duty paid. Now, this can take care of the situation in which a taxpayer has not paid the stamp duty or has made a wrong arrangement for stamp duty. Certain rectification measures can be taken. Now, concerning alternative bond arrangements, I think their lawyers and accountants will be able to deal with that. Do members have any questions? If not, then we will go back to clause-by-clause study of the bill. Thank you, Chairman. The Bills Committee has come to an advanced stage of studying the bill. We have only a few pages to go, and I've also prepared the committee stage amendments for members' scrutiny. Let us go to the Blue Bill. We are already in Schedule 6. This is 1315 of the English version of the Blue Bill. Schedule 6. Now, under the IRO, we would like to add a schedule. The schedule is made according to Section 29CA and DA, which is in relation to property held or formerly held under qualified investment arrangements. It is an agreement for sale or a conveyance on sale. This is to give exemption to the originator and the bond issuer. The property transaction between them will not be counted under the stamp duty ordinance, and such stamp duty will also be exempted. If in respect of the SSD, we will also provide the relevant exemption. Because of this, Section 29CA and Sections 29CA and 29DA have clear provisions in respect of the conveyancing of residential property and how stamp duty is to be paid. We therefore have to make suitable adaptation or changes so that Section Clause 47G, which exempts stamp duty, will also apply to exemption of SSD. Schedule 6, therefore, deals with the individual provisions and wording of the two sections I mentioned. This is to make sure that the originator, the entity getting land from a third party will have to pay stamp duty, but between the bond issuer and the originator, if it is there is any property transaction, and if it is for the purpose of the bond issue, then it will there will be exemption given. This is Schedule 6. Mr. Leung, can the Bureau clarify this? This Schedule 6 refers to SSD or BSD or what? We refer to special stamp duty only. As for BSD, will that how are you going to deal with BSD and also DSD? Now we will follow the same vein. Like the alternative bond scheme, whatever stamp duty involved will be exempted. In fact, these transactions do not occur. They are there just for the purpose of issuing the bond. As for the new stamp duty arrangements, there are two bills committees dealing with the relevant arrangements. And then they are discussing the matter at different stages. When the discussion matures, then we will, or when opportunity arises or matures, we will deal with the relevant provisions. Under the existing IRO, there are sections 29CA and 29DA, and we have to deal with them. As for the new provisions which are being considered by members, they will have to be dealt with later. After this bill is enacted into law, we may need to make relevant amendments. Chairman, I want to look at the technical side. Schedule 6 only deals with SSD. If you are to deal with DSD and BSD, later, are you going to change the definition in this schedule, or you need to add schedules 6A, 6B to do the amendments? I want to know what the Bureau is going to do on the technical level. Thank you, Chairman. At present, we have yet to draft the detailed provisions. As I said earlier, we follow the same vein. And that is, we are to provide the tax exemption so that any stamp duty caused by alternative bond schemes will be exempted. In the long run, will there be a new schedule or new schedules? We will have to wait for the completion of the discussion or clause-by-clause study of the other two bills. We have to wait for the outcome and consensus of the two other bills committees before we can do the drafting. And if need be, I will report to members.
I just want to ask, well, you think you are going to do the same thing along the same based on the same approach. But the stamp duty provisions have become very complicated as following the recent amendments. It wasn't that way in the past. So what are you going to do in terms of the amendments? What approach or direction are you going to take? Are you going to change the definition in Schedule 6, or do you have to draft a new schedule? If you have a new schedule, this bill will be even more complicated for users. I think the member has made a suggestion. Should you want to move further amendments, please don't complicate things. Please make it convenient for the sector concerned. If we can cover everything in Schedule 6, that would be better. Basically, we agree with the member. We'll try to make laws as straightforward as possible. In terms of drafting, we would take that into consideration in drafting future amendments. Can we be given a briefing on what Schedule 6 aims at achieving? I would like to defer to my colleague from the ILD to respond. Maybe I can briefly go over the sections, but the principles have been already been elaborated by Mr. Liu. First section, residential property transactions under qualified investment arrangement. B is about tenancy or the agency arrangements, and the property is held or was formerly held by the issuer. On B2, the relevant business undertaking must have held the property. C1 is about tenancy, agency, and transaction, buying and selling. And 2 is profit sharing. D, the issuer or specified asset transaction. Has already been exempted under 47(1)(f). Questions about Section 1? No? Okay. Section 2, modifications. 2(1) in Schedule 6 is about Section 20CA (1), (2), or 6. CA is about agreement. DA, conveyance. And these are about calculation of SSD, and also in relation to the holding period. These are the applicable sections. And then A applies to tenancy, transaction, and agency arrangements. B applies to profit-sharing arrangements. And 2(2) of Schedule 6 is related to 29 CA 5A, B, or 11, or 29 DA bracket 5A or B or 11, or subsection 1A 1 or 2 or B1 or 2, as the case requires. This is to dovetail the two sets of provisions. As for 29 CA4 and 29 DA4, this is section 3, and that is building is disposed of after construction on land acquired. So we want to make this applicable to the qualifying the investment arrangement. If you build something on a land site and a bare site and sell it, this would be covered by the modification mentioned here. And the bracket A is related to tenancy, the transaction and agency, and B, the profit sharing. Questions about section 2 and 3? No. Section 4? Section 4 is about modification in relation to CA4 and DA6, and that is if the land is acquired with building, again this is an exemption, and this exemption would apply to the relevant circumstances after modifications. And A is about tenancy, the agency, and transaction. B, profit sharing arrangement. Questions? No. Section 5 of Schedule 6. When the business undertaking make a contribution in kind, and this would apply if the business undertaking make a contribution in kind. And then we have a table setting out different reference provisions. For example, transferor, column 3, the original reference to relevant parties will be the same as a reference to some other parties after modification. This is to make it easier to read. Is this table following the schedule? Is this table part of the subsidiary legislation, or is it of no legislative effect? Well, this table has legislative effect, but this is just to express Schedule 6 or paragraphs 1 to 5 of Schedule 6. Would there be any discrepancy between the two? No. This is just to facilitate the reader. Well, last time they were wrong about the dates in relation to that instrument. Please bear this in mind. We cannot allow any discrepancy. We have done a lot of proofreading here. For example, item 1, we have 29 CA and 29 DA, 4, vendor and transferor acquiring the land on which the building is constructed. And this would be read as the bond issue acquiring the land from a third party. So that under an ABS, alternative bond scheme, the tax exemption will be allowed, and the transactions between those parties will not be subject to the stamp duty. And we'll look at the 29 CA, 29 DA, and different subsections and paragraphs for which a modification will be allowed. All right, let's move on to part 5. So this is part 5, miscellaneous amendments to the Stamp Duty Ordinance. Most of the amendments are needed because we have new provisions in the bill. Therefore, the existing provisions in the Stamp Duty Ordinance must be amended, and the relevant references have to be updated to include those applicable sections. For example, Section 2, interpretation, we have a definition of assessment, and we have to include new sections. In the second definitions of stamp duty, we have to refer to alternative bond scheme and its definition in the interpretation of stamp duty. And we have also taken the opportunity to add section 2.1 or 2.5, and if a penalty is to be imposed for a breach, then the penalty would be the amount equal to the fine shown in Schedule 8 of the Criminal Procedure Ordinance, Cap 221. Why do you have to have Section 2.5? What happened before that? It was the same, right? It was a Schedule 8 of Criminal Procedure Ordinance. Yes, it was interpreted in the same way. Was it spelled out previously in the Stamp Duty Ordinance? Or there's no explicit provision in the Stamp Duty Ordinance that the level of penalty will be linked to the Criminal Procedure Ordinance. To avoid misunderstanding, we would like to take this opportunity to clarify the fact that the penalty under the Stamp Duty Ordinance is based on the Criminal Procedure Ordinance. This has always been the practice in implementing the SDO. But we would like to facilitate the reader, because if you just read the SDO and it says the fine is level 4, level 5, you don't know what it is actually. So we just want to provide the reference to facilitate the reader. So have you been doing this in relation to the level of fines, and that is it's always based on the Criminal Procedure Ordinance? Yes. All right, Section 25 or Clause 25 is to amend Section 4 of the SDO. We are going to add new provisions. We add 5 capital A and 5 capital B after Section 4 bracket 5, and that is the Stamp Duty Office can collect the stamp duty within a certain time frame. And we're talking about the expiry of the time for stamping the instrument, or if there's a disqualifying event, and within 6 years after that, we can recover any stamp duty due. And we have already explained this to members. I have a question about 25(2) 5B, material arrangement. Why do you have to have this limb here? What's the legal effect that you aim to achieve? This is about 5A, B. That is an IA disqualifying event. And such an event is called a material arrangement. So we have to clarify which arrangements leads to the disqualifying event. It's just a label. The material arrangement is just a label. It's not a definition. It's only used in 5A.
We're just talking about the event, the disqualifying event, or the earliest disqualifying event, if such an event occurs. And also section clause 26 is about the amendment of section 13, and that is adjudication of stamp duty by collector. And we want to add 44.3, 45.3, and 47I.
Section 14 is in relation to appeal against assessment, and new provisions have been added here. The next page refers to existing provisions under the stamp duty ordinance will apply. That includes 18J, power of collector to cancel stamp certificates. Section 19, sale and purchase of Hong Kong stock contract notes, etc. Under 47F, 47F is added. And then amendment to section 45. Section 45 deals with relief in case of conveyance from one associated body corporate to another. And we have added the relevant provisions. 5A, 5 capital A, under 5 capital A. If you have the markup copy, we want to clarify the provision of existing subsection D to make it easier to understand. If the money has not been paid within 30 days, the transferor and transferee will be jointly and severally responsible for paying the fine. And if it is more than 30 days, then under Section 9, there are further penalties and additional money to be paid. And they also have to stamp the instruments. And E provides that the collector has the power to give exemption to the fine, partly or wholly. This is to make existing 45.5AD clearer. And this is in line with our existing provision or existing draft. Mr. Leung, 45D Roman 1.
Liable or jointly and severally liable, as the case requires, to a penalty. Now, 呢一個 Roman 1呢個小節呢，其實係咪
The Roman 1 deals only with 45 in respect of relief. If there is a fine, it is only limited to Section 45. Now, in the stamp duty ordinance, the transferor, transferee, or user of the instrument are jointly and severally liable for the underpaid and overdue stamp duty. The penalty is not paid by or will not be paid by the transferee. Is it the case? I don't know whether members have the markup copy. Page 84 of the Chinese version or page 99 of the English version. Now you can see the existing 45A, B, transferee and transferor and transferee are jointly liable.
呢度其實係講清楚，即係其實同原有嘅條文亦都係。
This is in line with the existing provision. The two are jointly and severally liable. Okay, thank you. Okay, shall we go on then? Now we've added E which says that the collector may remit the whole or any part of any penalty, and that will therefore benefit the taxpayer. Yes, Mr. Low. This is a reference to remission. Is there a provision on remission of penalty? Should there be a cross-reference? In the stamp duty ordinance, there is a provision to each section. I don't know whether it's Section 9 or Section 13. Yes, Section 9 on remission. Your drafting style doesn't require any cross-reference? Well, in fact, there are many such provisions in respect of various sections. I just want to put on record that the remission procedures follow Section 9. When there is a remission, all the taxpayers will follow the procedure under Section 9, right? I can confirm that. His understanding is correct. Okay, Clause 31 is about amending Section 58A by adding 47H and 47J. Representations made to the collector before certain penalties, remission of certain penalties of 58B. Under 58B, we add the new provisions, a reference to the new provision, and then we also add Section 69, which is a transitional provision, and we will spell out the details under Schedule 7, and we are to add the relevant new provisions, references to the new provisions under Schedules 1 and Schedule 7. Schedule 7 deals with the transitional provisions. It says that what kind of instruments are included, and it refers to the instruments that come into effect on, or rather the instruments that exist after the law comes into effect. Otherwise, those before the commencement will not be benefited. Any questions? Can you give me a minute so that I can study it further? Okay. I have a question on Schedule 7. Say, a certain Islamic bond was issued before the commencement of this ordinance, and it did apply for exemption under the procedures then you would follow the existing procedures to give exemption rather than following this provision. Yes, the answer is the affirmative. Under the existing Inland Revenue Ordinance, individual exemptions can be made. And we just want to regularize the arrangement. Now, the new instruments will have the exemption after the law has come into effect. As for there is exemption under the existing IRO. A discretion is given on a case-by-case basis. Legal advisor, do you have any comments concerning the provisions? In fact, my questions have been put in writing and sent to the authorities, and they have already responded to me. Our consensus will be reflected in the CSAs. I still have one question which I want the administration to consider, and that is about two stamp duty ordinance stamp duty amendment bills which are being considered. And these two bills will certainly impact on this bill. And the two stamp duty amendment bills have retrospective effect. The stamp duty collected or to be collected doesn't come into effect only after the bills are enacted into law. They have effect starting from the date announced by the by the administration. So there will be consequential amendments. So it is possible that the issuers of these bonds may ask for a refund. Under the existing under this bill, such a possibility has not been dealt with. Now, apart from incorporating certain provisions into the stamp duty ordinance, we also need another mechanism to allow application for refund after the new stamp duty ordinance comes into effect. And that is a bit complicated. I don't know whether this is an unreasonable demand. I hope that the administration will produce a simple document explaining to us the situation after the enactment of the two stamp duty amendment bills have been enacted into law. What kind of consequential amendments to this bill will have to be made? This is a sort of introduction so that we can have a checklist, and that will also facilitate our future study of related amendment bills. Yes. Now, after the enactment of this bill into law, the other two bills will then be enacted, and they may have a bearing on this ordinance or this bill, and that is also and also the property transactions that have been made before the bill comes into effect. Yes, we will produce a paper on that. In fact, we do have exemption given to Islamic bonds at present, even if the situation as described by the legal advisor occurs when the bill is enacted into law, and when the two other bills are enacted into law, and the two bills may have retrospective effect. The issuer may involve transactions of Hong Kong residential property, and they may have already they may be affected by BSD and DSD. In principle, we will give them the exemption so that the issuer can make use of Hong Kong as a platform to issue Islamic bonds. Under the existing Stamp Duty Ordinance Section 52, we can handle these cases on a case-by-case basis. The issuer can submit the documents to the collector of stamp duty, and then under the existing arrangement, if it is in line with our principles, then exemption will be given. So to answer the question of the chairman and the legal advisor, in short, we will continue to deal with the cases of tax exemption under Section 52. before the commencement of this bill. Now the two other bills are being considered, and we can only do drafting when the discussion and study of the two other bills are at a very advanced stage. And we will talk to the colleagues of the IRD to make the consequential amendments as simple as possible. And we will continue to give exemption under Section 52.
Islamic bonds are structured in such a way that they may be subject to stamp duties, and therefore exemption may be warranted, but we believe there aren't many such cases. So far, we haven't received any inquiry about this. So we would proceed in the light of actual situation. As the legal advisor has suggested, we can provide a supplementary paper for record purpose and also for members' reference. This will facilitate the work of the Bills Committee. Some other things, Chairman. Mr. Liu, there are two other tax bills. Inland Revenue Bill 2013, Inland Revenue Amendment Number 2, Bill 2013. In one of those Bills committees, it said that if this Inland Revenue and Stamp Duty Legislation Alternative Bond Schemes Amendment Bill cannot be passed in time, then there will be CSA to the Inland Revenue Amendment Number 2 Bill. Well, we have been able to achieve satisfactory progress for this bill, and this bill is being scrutinized along with the two other Inland Revenue bills. So perhaps, Mr. Liu, please communicate with your colleagues so that we don't have to end up with a lot of CSAs. Well, we are aware of this, Chairman. And even if CSAs are required, we are actually talking about the numbering of schedules and provisions. I have noted Mr. Leung's comments. We would do our best in internal communication to avoid this as best we can. When the discussion is already at a mature stage, I hope the bill can be passed as soon as we can. We have to wait until the two other bills are enacted before we add something here for the exemption, because we cannot assume that the two other bills would be passed as a matter of course. All right. I think we have completed the scrutiny of the bill itself. It's now time to consider CSAs, committee stage amendments. The paper we have just got has an annex. It's a CB 11215/1213. We have an annex, Annex B, English version. Let's go to English version for Annex B. There's a CSA there, but it's subject to the refinements by the law adjustment. But anyway, let's have an introduction from the administration first. Let's go back to the documents we discussed at the beginning of this year, and that is Section 14A, qualifying debt instruments. Because of the amendment in 2011 bill, there was a mistake with the date, and we hope through this bill we are now discussing, we can amend, rectify the mistake. In Annex B, we
set out the applicability, and that is that it would apply to the past debt instrument, and under we hope that the new definition can cover all these debt instruments, so that the amendment would apply to all of the time. And the new 2A and 2B aim at expressing this. And that is not, it's just not just after the amendment is implemented. We hope that even before the amendment is effective, the 50% exemption will still apply, and it would be deemed as if the exemption has always been applicable. We have discussed this with internally and also with our legal advisors. Questions? No questions? This is also in CB1 1213(03). This provides at a glance amendment in the form of a CSA, and depending on our discussion in the future and also the refinements by the law draftsman, so we would move this amendment. All right. So as Mr. Liu has said, let's wait for the final version from the law draftsman. And now let's talk about our timetable. Mr. Liu, would you like to say something about the annex in the paper 03? Yes, if I may, I would like to give a brief introduction. Although the wording is subject to final refinement, but I don't think the final version would be too much different from what we have here. So I would like to say something for members' reference and see if members have any special comments, or so that we can consider their comments in the final version. This is a paper 03, 1213(03). I'm sorry that we can only provide the English version because the drafting took time, but we would provide the Chinese version as soon as we can, and if we can get a consensus, reach a consensus in relation to the English version, the Chinese version can be drafted accordingly. This is a markup version, and we only clipped the provisions for which amendments will be moved, and we also set out the new provisions. Most of these are technical in nature. Sometimes it's just to make it easier to read, or to make the policy in legislative intent easier to understand. In past meetings, during the cross-by-cross, members offered a lot of comments, and we have proposed some amendments in response to their comments. Let's go to page 2. This is a Schedule 17A, bond issuer. That is the special purpose vehicle between the issuer and the investor. Some members ask whether something is a special purpose vehicle. And we confirm that yes, that's a special purpose vehicle. So we would like to get a clearer definition by providing a definition here.
And that is in relation to any scheme or schemes means a corporate or any other entity that is established solely for the purpose of a scheme or schemes, as the case requires, and does not carry on any trade or activities except for the purpose of a scheme or schemes, as the case requires. Mr. Leung, that this definition means a corporation or any other entity. So it means a company or something like that. I just don't know whether there's any special purpose vehicle or that may come in other forms. Even if there was any other entity, you may be talking about body corporate, an SPV in the form of a body corporate. And there's also a wider question here. I don't know whether, according to the Islamic bond market and practice, I don't know whether if an SPV is responsible for the issuing of one bond. This is for the purpose of a scheme or schemes in A. So the SPV can be for multiple issuances. Is this in line with the actual practice in the market? Two questions. When we draft this definition, we want to make it easy to use by the market players. So we want to go for something more general and encompassing. So usually it's a corporation. This SPV is a corporation. We add the words any other entity, because sometimes the bond is issued outside Hong Kong, and in different jurisdictions they may have a different definition of company. So we don't want to just have corporation denoting a company, but in other jurisdictions it may be called some other thing, and we don't want such a technical difference resulting in disqualification from the exemptions. So we add the words any other entity for the purpose of offering tax exemption. As for market practice, as Mr. Leung has said, most of them will be in the form of corporations. As for the second question, it's again a very valid point. Usually, an SPV is set up for the purpose of bond issuance without really fulfilling other purposes. But sometimes the bonds are issued as a series. For example, they have a master plan. Under the master plan, there are different issuances or tiers of issuances. If the SPV concerned is involved in a series of issuances, we don't think that the SPV should therefore be disqualified from the tax exemption, and therefore, as you can see on page 5, there's another rule on construction, and that is that if there's more than one scheme, we can still accept that as a special purpose vehicle. But the common practice is to have one special purpose vehicle for one bond issuance. We just want to provide a flexibility to cope with different arrangements. Well, I find this agreeable, but let's clarify. Any other entity is well, I don't know anyone would use a partnership as an SPV. Would the word entity include a partnership? And also,
after using the term special purpose vehicle, are you not going to use the term bond issuer? If not, if you're going to use both, then when do you use SPV? When do you use bond issuer?
第一個問題，
Thank you, Chairman. Concerning the first question, entity is a broad term. I believe it does cover different kinds of corporate structure. I don't know whether those from the ILD can supplement. Concerning the understanding of other entity, we need to look at the purpose of the bill and also the actual operation. It really depends on the circumstances. Even if can we have an opinion on the interpretation of the term entity? I don't want to extend to other bills, but just this bill, within this bill. And our intention covers different forms of business structure to facilitate the issue of bonds. Mr. Liu, and also about wording concerning SPV and issuer. When do you use this and when do you use that? Now concerning the definition of SPV, or after we have the definition of SPV, we say that the bond issuer is the SPV. As for subsequent provisions, it really depends on the circumstances of that provision. On page 3, now the structure of the alternative bond scheme, we cross out the we say the bond issuer is a special purpose vehicle. We cross out the definition. Now, since it has been defined, and then a reference can be made by, when we read the subsequent provisions, and that will facilitate the interpretation of the law. Page 4 is purely technical. It refers to section 3(2)(b), and when the situation occurs, reference is made to this particular provision. Originally, it was 3(2). Because of technical consideration and for the avoidance of doubt, we put it down clearly. Page 5 is in relation to Schedule 7. Now we've defined SPV right at the start. Any reference to person or entity, so on and so forth, we replace them by SPV. Amendments in pages 6 and 7, just for spelling out the cross-reference, which section or subsection or subsection. Page 8. Page 8 deals with a lease arrangement. If the assets are damaged, the bond issuer can replace the assets. They can use insurance money and other compensation to buy new assets. I've noticed that the Law Society has a view, which is replacing "and" with the word "or" to provide greater flexibility. We agree, and therefore we make a minor amendment and replace the word "and" by "or." Earlier on, when we replied to the Bills Committee, we informed members that we would make such an amendment. Any questions of members? Page 9. This is only a minor drafting amendment from the originator. Is put after the cross-reference. It doesn't affect subsections 1 and 2. That is in response to the advice of your legal advisor. Page 10. It is about profit-sharing arrangement. We want to spell out two different arrangements, including Mushuraka and Muduraba. If it is paying money and other things, then it is regarded as Mushuraka. In fact, that was raised by members is reasonable. We just want to spell it out. We therefore add the word only after the Muduraba arrangement. Page 13 is in relation to agency arrangement. The bond issuer may pay the originator an agency fee or an incentive fee or both. And that provides the flexibility. The agency fee may not be fixed. There may be an incentive fee, and it may be both. We just to provide flexibility. This is in response to the Bills Committee's questions. All right. Then we move on. Chairman, we may have a minor amendment concerning clause 10, and then we'll inform you later. And then we move on to page 22, which is an amendment to Schedule 721(4)(a). This is without limiting subsection 3A. This is in line with the arrangement under subsection 5. We just want to spell it out clearly that we will disregard business undertaking bond issuer. Will disregard the interest or acquisition of interest by the bond issuer, and the relation with section 7(3)(b) is not very strong. We therefore want to spell it out, saying that without limiting subsection 3A. Page 24 is also a technical arrangement. This section applies for the purpose of this part. We spell out subsections 2, 3, 4. Instead of this section applies. Section 23, in fact, provides an interpretation for Part 3 of the schedule. Page 26. A member, after a meeting, raised this with me. In fact, it's Mr. Leung. It's about 51C. The provision applies to a person who carries on a trade, profession, or business in Hong Kong. In fact, Mr. Leung says that we don't need to repeat that. We go back to talk to the IRD, and we find the suggestion reasonable, and therefore we cross it out. Page 30. Page 30 deals with objections. You may recall at the last meeting, if a taxpayer faces a disqualifying event, the taxpayer can object to that and raise the objection with the Commissioner of IRD. And the objection will be regarded as objection of assessment for all the years instead of a selective objection. That is, one only objects to the assessment that is unfavorable to him in a certain year and not in other years. We want to spell it out in the provision. if the taxpayer disputes a certain assessment, then it will be regarded as a dispute against the dispute of in relation to assessments over all the years. Now, as for section 30, or rather page 31, we want to amend the dates, and we deem all the instruments that have been given exemptions within those dates. Page 34. Page 34 deals with the amendment to 47F. We change a part into part 4. The meaning is the same. It is just a drafting style. 47G. We add the security arrangement in respect of relief. Under 47F, there is an arrangement of security, and it applies to 47F and 47G. So it is just along the same line. Any questions from members? 47G. Can you explain to us why you need that amendment? Now, under the stamp duty ordinance, 40F deals with property conveyancing or purchase and sale. And under ABS, if there is any transfer of assets, and then under 47F, there will be tax exemption in respect of stamp duty. I explained that under 47F3, subsection 3, we require the taxpayer to pay a security first to make sure that the IRD, having considered the application and has decided on exempting the stamp duty, then there will be a refund. That is the arrangement for giving tax exemption. And 47G deals with sections 29CA and 29DA, the exemptions arising from SSD. We do want to provide exemption under SSD, and we want to include the security arrangement. It's not just under ordinary stamp duty you have to pay a security, and when you have exemption under SSD you don't need to pay a security. That will cause a discrepancy. We therefore add 47G 1A, requiring the taxpayer to make a payment. It's not directly related to Islamic bonds. No, it's not. You just want to amend it when the chance arises. It's about Islamic bond, giving exemption to Islamic bonds from SSD. We just want to make sure that before we decide that they can be exempted, they have to pay the security. Page 36, 2A. 1B is in relation to the security. As for 2A, we spell out the reference to subsection 1, and 2B we spell out the cross-reference. 47H, respectively, is added. It is a drafting issue. It just spell out it is the bond issuer and the particular persons are respectively the originator and bond issuer. Okay, page 38. Page 38. amendment to 47F and G. If there is a disqualifying event, there is a chance that the scheme would be, or the bond would be disqualified, and stamp duty will have to be paid.
就講到明。
We amend subsection 2 to specify that the special stamp duty will be recovered. And we want to specify that in the case of withdrawing the relief, or it may be a full relief, or it may be about a reduction of duty payable. So both can be applied in case the relief is withdrawn. In the case of total relief granted or partial relief granted in the first place, after the disqualification event, we want to have this clear provision to avoid any anomaly. Page 40 is the same. We are now on page 42 and page 43. As we have discussed, it's about 45 bracket 5 capital A bracket C. This amendment, we substitute have relief not been granted under this section to make it consistent in terms of drafting. This is to replace as if no relief from stamp duty have been granted by the collector under this section. No policy change is involved. Chairman, that's what the administration would like to propose as CSAs. Most of them are technical amendments. Additionally, there would be two more amendments to be proposed. And then we're also going to prepare a Chinese version to be sent to members for your scrutiny. As we have already handled the English version, would you agree that we communicate with your legal advisor over the Chinese version instead of asking members of the Bills Committee to do it again? But there are the amendments that you may submit. We may need one further meeting. And then we can study all the amendments in the final stage. Okay, so we are going to provide the papers as agreed, and then we can give you the Chinese version together with one or two more CSAs, and then we can handle all these in the next meeting. When can you make available the Chinese version to us?
秘書，我哋而家係
What about our meeting slots? The next meeting will be on the 7th of June. If you can give us the documents before the 7th of June, that would be best. If not, we better cancel the meeting schedule for the 7th of June, and then we can move on to the next slot, the 13th of June. Would you like to go for 13th of June? Yes, to give us ample time, I would prefer the 13th of June. The initial thinking, initial inclination is to have this passed before the summer recess. We hope to resume second reading on the 10th of July, and then we can have the second reading debate and the third reading. So if we
meet on the 13th of June. There will be time for the report to be submitted to HC, and then we can give notice to the Leg Code for resumption of the debate. All right, so we are going to meet again on the 13th of June at 10:45 a.m. Let's hope that we can wrap up and consider all CSAs, including the Chinese version, in that meeting. Please give us the Chinese version in good time. Yes, we aim at doing that so that we can consider all the CSAs at in the next meeting. I hope I'm sure the next meeting will be a short one. All right. I have to remind members about the timetable. As Mr. Liu has said, the administration would like to have the bill, the second reading debate of the bill resumed on the 10th of July, and for this we have to report back to the House Committee on the 21st of June, and the notice period deadline for resumption of second reading is the 24th of June, and that is to say after the next meeting. If there's nothing more to handle, I will report back to the House Committee on the 21st of June, and then on the 10th of July, second reading debate will be resumed. To propose CSAs, the deadline is the 29th of June. And having given members, administration's CSAs, and members want to move your own amendments, please make sure that you propose your CSAs by the 29th of June. Legal advisor, I think that's okay. That the timetable is okay. If not, there's nothing else to handle. The meeting's adjourned. Next meeting, the 13th of June at 10:40.